We are 20 seconds to live. Mayor Davis, we are live on, please proceed.
Thank you very much, Madam Clerk. So welcome everyone to this special City Council meeting. The purpose of tonight's meeting is it's a special City Council training session having to do with the city's new code of conduct. So Madam Clerk, would you please call the roll?
Certainly. Councillor Weaver,
Present.
Councillor Utley,
Present.
Councillor Sless,
Present.
Councillor McCreary, Councillor McCreary.
Yes, I'm here.
Thank you. Councillor Martin,
Here.
Councillor Antosky,
Here.
and Councillor Wall.
Present.
Mayor Davis.
Present. All right, as I normally do, we have a virtual meeting. I have to
I'm here.
remind everyone of the rules of procedure. And so all members should be muted unless you're speaking to reduce feedback. All web cameras shall remain turned on through the duration of the meeting. Staff are requested to join the video meeting as and when required to answer questions from members of council. Any member of council can indicate that they wish to speak. Please push that raise hand button in the participants box, and I'll then recognize you based on the order given to me by the participants box. The clerks, you don't have to lower your hand. The clerk staff will do that automatically once you have begun speaking. In the event of an interruption, an IT interruption, we'll try and maintain or try and regain the internet connection. But if that's not done within 15 minutes, the meeting will then be adjourned. So are there any declarations of a pecuniary interest that any member of council wishes to make tonight concerning the item that's on our agenda tonight? Seeing no raised hands. Oh, Councillor Carbon, did you raise your hand?
Yes, they missed me in the queue on present, so I am present.
Yes. Councillor Carpenter is present. All right, so we'll begin the education training session. As per section, I believe it's 15.6.3, presentations to council are supposed to be limited to 10 minutes, inclusive of questions from members. I think given what we're dealing with tonight, if nobody has any objection, I'm just going to waive that as the chair of this meeting, and we'll put no time limit on Mr. Huberman's presentation, although I understand his opening is fairly short. And you can ask as many questions as you want and speak as long as you want, subject to reason. So I'm not seeing any objection to that procedure and process, which I think is appropriate for a training session. I'd ask them, we have a special guest tonight, Marvin Huberman, I believe I'm pronouncing it correctly. He is from ADR Chambers in Toronto. He is a solicitor, and he is the City of Brantford Integrity Commissioner. And we also have with us from the legal department, Heidi DeVries, I understand you're here. And did you want to provide us with a brief introduction for Mr. Huberman?
Absolutely. So through you, Your Worship, I'll provide a brief introduction for Mr. Huberman, as well as a brief introduction as to how we got here with our new Code of Conduct. Some of this background was already provided to both the Code of Conduct Task Force and to Council as per our previous report on this topic, but for everyone's benefit, including the viewing public, I'll reiterate some of that background information for you here tonight. So on May 30th, 2017, Modernizing Ontario's Municipal Legislation Act 2017 received royal assent, affecting amendments to various acts, including amendments to the Municipal Act 2001. Included in those amendments was a new requirement that municipalities in Ontario establish codes of conduct for members of the council of the municipality, as well as its local boards. This requirement took effect on March 1st, 2019. Additionally, the province of Ontario prescribed certain subject matters which must be included in codes of conduct for members of council and local boards, pursuant to Ontario Regulation 5518. That regulation requires that codes of conduct include provisions to address the following subjects at a minimum: gifts, benefits, and hospitality, respectful conduct, including conduct towards officers and employees of the municipality or local board, confidential information, and the use of property of the municipality or local board. So on February 26, 2018, City Council passed a resolution adopting a new code of conduct, which is now found at Chapter 16 of the City of Brantford Municipal Code, which is available online, which contained provisions required by OREG 5518, but also directed the Code of Conduct Task Force to undertake a review of this new chapter and report its findings with any recommended amendments thereto to Council for its consideration. The Code of Conduct Review Task Force met several times over the last year in order to update the various provisions of Chapter 16. Specifically, the Code of Conduct Task Force was reviewing amendments with a view to the use of social media. On May 4th, that task force recommended to Council that comprehensive amendments to the Code of Conduct be developed to bring the city's Code of Conduct in line with comparator municipalities. To that end, I worked with both Mayor Davis and the city's Integrity Commissioner to develop a new modernized code, which was presented to the Code of Conduct Task Force on June 11th, 2020, and was further adopted by Council on June 23rd, 2020. So that's a little bit of a background to how we got here with a new Code of Conduct. And just a brief introduction to follow up on what His Worship presented with respect to our Integrity Commissioner. The city has contracted with ADR Chambers for Integrity Commissioner services, which we did on January 28th, 2020, at the same time that we appointed Mr. Marvin Huberman of ADR Chambers as the city's Integrity Commissioner. Mr. Huberman is a senior corporate commercial litigator, a mediator, a workplace investigator, Integrity Commissioner, court-appointed corporate monitor, commercial arbitrator, certified construction adjudicator, former vice chair of the Commercial Registration Appeal Tribunal, and a deputy judge of the Small Claims Court in the Toronto region. His legal career spans over 30 years, in which Mr. Huberman has consistently appeared at the forefront, dedicating his knowledge, experience, and energy to developing and advancing the legal profession. I noted as well that he's also a recipient of several awards and recognitions, including being accredited by the ADR Institute of Canada with the designation of Chartered Arbitrator. He is a recipient of a dedicated professional service award from the Canadian Bar Association. And my personal favorite, he has been awarded a first-degree black belt in Taekwondo. So clearly he is a man possessed of many skills when it comes to the art of resolving a conflict. So welcome, Mr. Huberman, to this special meeting of Brantford City Council.
Thank you, Heidi, and thank you, Mayor Davis and councillors and staff for affording me the opportunity to present on the topic of the new Code of Conduct for the City of Brantford. I begin with a quote from a 1936 article written by Fred Rodell titled Goodbye to Law Reviews. And of course it was published in a law review, and I think it's written a bit tongue in cheek, but what I take away from that is the quote that says, there are two things wrong with almost all legal writing. One is style, the other is content. And I have to say that in reviewing your new Code of Conduct, that commendation is owed to the chair and members of the City of Brantford's Code of Conduct Review Task Force. And a special shout out ought to be given to Heidi DeVries, your city solicitor and director of legal and real estate services, for producing a new code of conduct that has both style and good content, in my view. What I'd like to do is to look at your new code of conduct through 5 lenses, namely, first, through the eyes of the Municipal Act 2001. Second, through regulations made under that act, particular one regulation Heidi mentioned. Third, through the City of Brantford's procedure bylaw. And fourth, having regard to other codes of conduct in other municipalities or even outside of Ontario. And looking at perhaps 1 or 2 Integrity Commissioner decisions or other other case law decisions that might come up in regard to our topic. And then lastly, looking at your new code of conduct through a discerning or a critical eye. And then I'd like to, and if you like, I'm pretty flexible, you know, feel free to, subject to Mayor Davis's direction, you can ask questions of me anytime, or if you want, you can wait till I go through my introductory comments, and then we can open up the floor then. I'm totally in your hands.
Well, I'm going to suggest, given that I'm the chair and I can make these rulings, that since you're going to do it in 5 different sections, why don't we take a pause at the end of each section and then call for questions relating to that section of your presentation.
Great. Okay, so let's do it that way. So Heidi, set the table firstly by saying that this all has to do with how municipal government works pursuant in Ontario, pursuant to the Municipal Act 2001. Now, of course, that act took effect on January the 1st, 2003. It was the first comprehensive overhaul of Ontario's municipal legislation in 150 years. And now it's the cornerstone of a new, stronger provincial municipal relationship. In January of 2007, the Municipal Act 2001 was significantly amended by what was then called Bill 130. And then it was again amended on March the 1st, 2019 through Bill 68, otherwise known as Modernizing Ontario's Municipal Legislation Act 2017. And it came into force just over a year ago. And pursuant to that, the key section there under the Act is section 223. And the key part of that is that it talks about codes of conduct under this section. And the code of conduct is now required to be established by municipalities for members of council and for its local boards. You've done that and before, and now you've done it with your new code. Section 223.3 refers to the integrity commissioner, the fellow who you've appointed in me. And what my job is under section 223.3 is essentially 7 tasks, which include the application of the code of conduct for members of council and for members of local boards. That's what we're going to talk about tonight. We're going to talk about the new code and its application to members. And secondly, my task would be, in another sort of context, would be the application of any procedures, rules, and policies of your municipality and your local boards governing ethical behavior of members of council and local boards. That's a second task that I have been given under the Act and under the contract you have with ADR Chambers and with me. Also, I can apply various sections of the Municipal Conflict of Interest Act to you as members of council and to local boards. And that in your new code is memorialized and referred to at the end in the complaint procedure. So you'll see, won't get into it unless you ask questions about it, but there's essentially two ways to make a complaint against you as members of council, local boards. Essentially is through the general complaint form for breach of the code. And secondly, through what we'll call the MCIA procedure, which is the Municipal Conflict of Interest Act. And that has a different form that you have to fill out as an appendix to your new code. So if somebody wants to make a complaint, they use either one form or the second form or both. And that's also rooted in the Act. Also, you can request of me advice concerning your obligations under the Code of Conduct. You can also request for advice respecting your obligations under a procedure, a rule, or a policy that relates to and governs your ethical behavior. So if you have any questions, you can ask for some advice. That advice can also relate to your obligations under the MCIA as well. So there's 3 ways you can ask for advice. And lastly, my task is to provide you with educational information from members of council, members of local boards, and the municipality and the public about codes of conducts for members and Conflict of Interest Act things. So tonight fits squarely within the mandate in the act, and it covers code of conduct and educational information and training. So basically that's the main section that establishes an obligation for you to create your new code of conduct. And it also empowers you, requires you, and empowers me to do various things as your integrity commissioner. So pretty much that's the main section with respect to those two topics. All right, so maybe I can stop there because my next topic, the lens, will then be through the regulation 55/18, which Heidi mentioned at the beginning, but I'll just review shortly in a moment also. So perhaps I can throw it open for questions if there's any questions about section 223 or the authority to enact or pass a code of conduct and appoint an integrity commissioner.
Yeah, so Mr. Hubbard, I don't see any questions, but I'll ask you one. And you mentioned our procedural rules for our meetings. And you're quite right, they do interact with one another. The procedural rules to the code of conduct, both the past code of conduct and the new code of conduct. Do you see a need for us to review or revamp our procedural rules in light of the new code of conduct?
I don't think it's necessary. Again, how they marry up precisely with the new code and whatnot, is something that we could take a closer look at. I've looked at it for the purposes of tonight's presentation, and I will highlight some of the key provisions in there that you may or may not be aware of, but should be aware of. And again, these are the sort of things that may be more of a contextual thing. If something comes up that might be problematic, we can have a look at. At the moment, Mayor Davis, I'm quite satisfied that your procedure bylaw does the job.
Another question I have for you, your role as the Integrity Commissioner, you mentioned that, the long experience you've had. Do integrity commissioners, do they normally give written decisions, and is there any way for a counselor or a member of the public to access written decisions of integrity commissioners, whether it's an integrity commissioner for the city of Brantford or for other municipalities?
Right, so if there's a formal complaint, then the decision has to be in writing. And so that's the answer to that. And it also has to be published by the municipality. And then the issue is it anonymized, is it not? That's a discretionary thing on my end. And also you have some discretion as to what you might do as well. But mostly, I think the answer is formal inquiries that where complaints are launched must be in writing. And there is a, if you go to Canley, CANLII dot, I think it's .org, if not mistaken. I use it every day, but it's a database for decisions. And you go to Ontario, you'll see a collection of decisions which you can search by topic or case name or whatever for Ontario Municipal Integrity Commissioners, OMIC decisions. It's a little curious that there's a fair number of decisions over the last few years, mostly by Guy Guillermo, who's an integrity commissioner for a couple of places or a few places. And I gather the reason is, after I've sort of looked into it, is he writes his decisions in the format that Canley accepts. So he gets his in there and you can search them. And I found them quite helpful, actually. There's a few other integrity commissioner decisions on there as well from others, but yeah, that's a source of integrity commissioner, to sort of a data bank for those sort of things. And yeah, for the last few years, there's some decisions on there you can search by name and by content and in that Canley database.
Sure. I see Councillor Sluss has raised his hand. Councillor Sluss.
Thank you, Mr. Mayor. As you indicated, Mr. Huberman, this applies to members of council and local boards of the city of Brantford. Are the local boards going to get the same oversight that we're getting from you in I guess a crash course on how to behave properly?
Well, it was an initial training session or introductory session was scheduled, but I think COVID kind of gummed that up. And I think the idea or it was for the local board, of which you have only one, right? The BIA. So yeah, that was canceled or postponed, and I understand that it is to happen at some point, but it hasn't been scheduled, rescheduled.
Okay,
Yeah.
thank you.
Well, Mr. Huberman, I think that's it for that section in terms of questions.
Okay, great. The second lens is of course, you've got to comply with the regulations made under the Municipal Act. There are a number of regulations, but there's really one for the topic for tonight. There's really only one regulation, and that's Regulation 5518, which is the prescribed subject matters. Now, Heidi mentioned that, and essentially, there are 4 prescribed subject matters that must be in a code of conduct. And I can say that they are in your new code of conduct, so you've satisfied the regulation, and they relate to gifts, benefits, hospitality, respectful conduct, confidential information, and use of property of the municipality or of the local board, as the case may be. So the bare minimum that must be in your code of conduct is satisfied, has satisfied the regulatory requirement. So that's what I have to say about that. Of course, your code includes a whole bunch of other things, which I think is commendable and desirable, and I would even say necessary as well. And we'll talk about that and what I think are some excellent features of your new code of conduct when we get to it shortly. So anybody have any questions about regulations?
I don't see any.
Okay. Not the most exciting topic anyway, the regulation. Okay, so the next lens I'd like to take you to, and this is really setting the table for what I think everybody's looking towards, which is questions and answers, or looking at certain provisions in the code, which they might have some questions or concerns. I understand that there's also, it wasn't unanimously passed. There was a dissent, and yes, and that's all fine and good. And a lot of that has to do with maybe a provision or two in it. And it's definitely important to talk about that. But before we get there, I think what I need to do is sort of set the table with these lenses. And then I think maybe some questions might be resolved before they're raised. And if they're not, let's raise them and we can talk about it having regard to these sort of considerations. Okay, so the procedure bylaw, of course, is chapter 15 in your municipal code. It's quite lengthy. I'm not going to go through it. You're all familiar with it. And I'm sure Mayor Davis, as the chair, is very familiar with it. But a couple of sections I think are noteworthy. One is Article 2, which is 15.2.1, which says that unless council authorizes the application of alternative procedures, this chapter, which is the procedure bylaw, shall apply to proceedings of municipal council in the city of Brantford, committees created or continued with necessary modification, to all boards and the advisory committees created under chapter 26, task forces created by council, et cetera, et cetera. So it's mandatory, unless you say otherwise, that this procedural bylaw applies to whatever you do substantively in terms of your committee meetings and so on and so forth. And the next article is also important to note, which is 15.2.2, which says council statutory obligations. It says council shall fulfill all of the statutory obligations of a municipal council, including without limitation on the et cetera, But the bottom line is that it reiterates an obligation to comply with, fulfill your statutory obligations. Not that if it didn't say that, you wouldn't already have to fulfill them anyway, because they're statutory obligations. But it's important to note that you and your wisdom have decided to reiterate that as a core principle, so to speak, in the procedural bylaw. So keep that in mind when we look later at what your statutory obligations as councillors are, and as a municipal council generally are as well. Okay, so there's that. And then basically we can skip all the way towards the end to Article 17. Now this is extremely important. It's headed accountability, and it quotes in Article 15.17.1 the purpose. And really, without reading it, it just reiterates paragraph 5 of subsection 270 sub 1 of the Municipal Act 2001, which basically says that you have to provide guidance and have policies when it comes to accountability and transparency. Well, you've done that in Article 15.17.2, and you've actually defined accountability and transparency there, and then ultimately apply that as a policy statement in 15.17.3, which really incorporates the core principles of good governance. So just to highlight, accountability in your definition means the principle that the municipality will be responsible to its stakeholders for decisions made and policies implemented, as well as its actions or inactions. Okay, so that's important to note, and we'll maybe come back to it later. And transparency is defined by you here as the principle that the municipality actively encourage and foster stakeholder participation and openness in its decision-making processes. Additionally, transparency means that the municipality's decision-making process is open and clear to the public. And then you go on, I won't read this whole thing, paragraph in 15.17.3, your policy statement, but basically in the middle of it, it says accountability, transparency, and openness are standards of good government that enhances public trust. They are achieved by way of the municipality adopting measures ensuring to the best of its ability that all activities and services are taken utilizing a process that is open and accessible to its stakeholders. In addition, whenever possible, the municipality will engage its stakeholders throughout its decision-making process, which will be open, visible, and transparent to the public. So I throw that out there. I think it's a core principle in your procedure bylaw and in the Municipal Act itself. And it comes into play when one is dealing with the application and the interpretation of your new code of conduct. So we'll come back to it if we need to later. Okay, so that was the third lens. Does anybody have any questions relating to your procedure bylaw, its purpose, its application, and particularly the accountability and transparency section?
Don't see any questions, Mr. Huberman.
Okay. All right, let's look then a little bit closer now at the role of council with reference to a couple of things. So one thing I'd like to draw your attention to is the Municipal Act 2001, Section 224, which says that it's the role of council to do a number of things. One is to represent the public and consider the well-being and interest of the municipality. That's little a. Little b is to develop and evaluate the policies and programs of the municipality. And then we skip to little d, which says to ensure that administrative policies, practices, and procedures and controllership policies, practices, and procedures are in place to implement the decisions of council. Now, just to add in a little dictionary definition of the word implement, that means to put a decision into effect. Okay, so there's a statutory obligation on you as a council to ultimately ensure that the practices, policies, and procedures are in place to put a decision into effect, i.e. implement the decision of council. And then little D.1, which was added with these new amendments that were brought in March of last year, to ensure the accountability and transparency of the operations of the municipality, including the activities of the senior management of the municipality, etc. So that's, I throw that out as a standalone statutory obligation, but I also refer you to, I mentioned it in our first session we had to introduce me to you, there's a Municipal Councillor's Guide 2018 that's been published by the Ontario government, and which has text that goes with this as well. And the text, just to paraphrase the text of the Municipal Councillor's Guide on page 2 of 11, it says, in other words, the key responsibilities as a councillor are to support the municipality and its operations while ensuring that the public and municipality's well-being and interests are maintained. So that's the provincial government's interpretation or commentary on that particular role on that page. As well, there is a role of the head of council, in this case, Mayor Davis's role in section 225 of the Municipal Act. I won't go through that. It's obviously to act as chief executive officer and preside over council meetings, et cetera, et cetera. And the commentary on that on page 3 of 11 says municipal decisions, however, are made by council as a whole. Generally, the head of council does not have any more power than any other member of council to make decisions on behalf of municipality. Each member of council only has one vote. So this is the core of democracy. You each have one vote, including the head of council, who has his or her own distinct role in the statute. But ultimately, when you do take a decision, you make a decision as council, it's a group decision. It's a decision that's taken as a whole. And ultimately, that's what the democratic process in making your decision entails. Now, you may say, well, we have more than one role, and that's true too. So the guide also talks about how, as a councillor, you have 3 main roles to play in your municipality. First, you are a representative, and second, you're a policy maker, and third, you're a steward. So the representative role that you play is in section 224 that I highlighted, and it's little a. You represent the public and consider the well-being and interests of the municipality. All right, and sometimes you have conflicts of issues, a specific issue, a constituency issue, wider issues in the municipality that need to be dealt with by council as a whole. And basically, you're going to have to consider your the different evidence that you've been presented with and submissions and so on and so forth. And you got to take into account all available information. But again, this guide says on page 3, working as a team with the rest of council and staff will contribute to making your time on council a success. Disagreements among council members are common, but it's important to remember that you're working towards a common goal. And I think that's the key. The decision that you make after a vote, and after all that comes before it, and we'll talk about it soon in terms of what it entails to make a decision, that all precedes the end result, which is the decision. Once the decision of council as a whole is made, whether there's a dissent or disagreement or whatever, doesn't matter. The decision of the majority is the decision of the group as a whole, and that's working then towards the common goal that's now been established by the decision. The policy-making role is essentially provides direction to municipal operations. And again, that's also identified in section 224. And that is little b, which says your role is to develop and evaluate the policies and programs of the municipality. And that involves a number of steps and requires council to do a number of things. But ultimately, you have to make a decision based on the best course of action available and develop a policy based on all of that. And you also have to direct the staff to implement the policy. So there's that policy-making role, but once that's done, you have to direct the staff to implement the policy that's been passed by the majority of your council. Now, lastly, the stewardship role is essentially ensuring municipalities' financial and administrative resources are being used as efficiently as possible. And there you have a chief administrative officer to help in that role, which is section 229 of the Municipal Act. And ultimately, to be effective in your stewardship role, the guide again says, you may wish to have processes in place to help ensure that policies adopted by council are being implemented. So again, once the policy has been decided by council, it's your job in your stewardship role. You're wearing 3 hats. This is the 3rd hat. You have to ensure that those policies which are adopted by council are being implemented. And then that would involve the role of staff, which again, the role of the officers and employees of the municipality are set out, is set out in section 227 of the Act, and their statutory obligation is to, among other things, to implement council's decisions and establish administrative practices and procedures to carry out council's decisions. So the way it works is that you devise the policy, you have a vote, you decide on what decision is going to be made, what policies are going to be implemented, and officers and employees, staff of the municipality have a statutory obligation to implement the decision. Now, how does that interact with your role as well? So then you get into council staff relationship and roles. And again, the guide talks about that as well. And the high importance of good council staff relations, which your new code also, I believe, addresses. And ultimately, you have to recognize the experience and expertise of staff, encourage communications between management staff and council. And ultimately, though, that you have to ensure that and understand that your relationship between staff and council is intertwined, and that you and other council members and staff must respect each other's roles so that you can serve and they can serve the public in an effective and efficient manner. If you're not allowing, or you're preventing, or you're interfering with staff in their statutory obligation to implement decisions of council and policies, then ultimately you're not allowing them and even interfering with their statutory obligations to do what they're supposed to do. So that may take a little bit of a different spin on what you're used to hearing in that regard, but that ultimately that's basically what everybody's roles are. And what I'm going to do is I'm just going to highlight a decision. Mayor Davis asked me about data bank or whatever of integrity commissioner decisions. There is a recent decision of integrity commissioner Giorno. It's dated January 25th, 2020. In the case of the Linton against Kitras, Kitras. And if you're going to go to Canley, you can look it up under that, Linton, Linton, small v period, Kitras, 2020 ONMIC 1. and that's Ontario Municipal Integrity Commissioner decisions. And ultimately, I won't take you through the whole decision, but what Integrity Commissioner Giorno confirms is what I've just been telling you, that ultimately the democratic nature of the office of being a council member means that council members have political and representational roles in addition to their legislative law-making role. So those are the three hats I was talking about before. And he says the courts have confirmed that municipal councillors have hybrid political and legislative functions, that they are representatives of the communities that elect them, and that members of the public have the right to address their municipal representatives on issues of concern. The Municipal Act confirms that a role of the council is to represent the public. Now, it also confirms that the role of councillors are also to do other things as well. So he's basically saying that you're allowed to have views, you can debate, you can disagree, you can be a contrarian, all you want to, as far as your democratic right to represent your constituents go. And that's sort of the political representational role. What he doesn't go on to say is, well, how does that interplay with the other two hats that you wear? Your decision-making role, your stewardship role. And I think what I've tried to do is highlight that those are other roles that are intertwined and coexist with your legislative and sort of with your representational and political role, and that you have to strive mightily, essentially, to combine the three role and comply with your obligations that relate to all three. So that's what I'd like to say about sort of the role of council, the role of councillors and staff, and in connection with your statutory duties. And maybe we could open it up if there's any questions about that as we sort of lay the foundation for looking at the code.
Yeah, I've got a question for you, Mr. Huberman. So I understand what you're saying, that, you know, it's essential to have, you know, vigorous debate when called for. But how do you draw the line between that and the code of conduct, which talks about, you know, being respectful, you know, and that line of,
right?
So where's the line drawn? Is it possible to say generally where it's drawn between, you know, a good hard debate, the rough and tumble of democratic debate, and when is it cross the line into you know, violating or contravening some of the standards of conduct that we have set out in our new code of conduct?
Right. So that's an excellent question. And there isn't really a bright line that is definitive in every situation. And the reason why I say that is because, and this is sort of the prelude to getting a little bit deeper into that issue, by first setting the table about when you're looking at a code of conduct, the code of conduct essentially is subordinate legislation. It's the product of a bylaw that was passed, given under the authority of a regulation, which is given under the authority of the Municipal Act. So the case law on that essentially says, and you know, and of course, to apply the code of conduct, more often than not, unless it's usually not so black and white, it's usually gray, that would therefore by necessity entail not only the application of the code to the context that we're dealing with, but also the interpretation of what the heck does it mean, right? What do the words used in the act mean? What do the words used in the regulations mean? And what do the words used in the code or the procedural bylaw mean? Many times you'll have a dispute as to what they mean. And Mayor Davis is quite right. You get a lot of this in, you know, did I disrespect somebody? Did I have lack of candor? Did I go overboard, whatever the, you know, word you want to use is in the code. And then that generally then means, well, what does respect mean in the context of the code? what does respect mean in the context of your democratic rights? And that's exactly right. So the reason why it's important to understand this is because ultimately the principles, what's happened is statutes, regulations, and codes of conduct are now governed by the modern principles of statutory interpretation that apply to interpreting municipal bylaws, statutes, and codes of conduct. And ultimately, what that means is what the Court of Appeal in Ontario has said not too long ago, a fairly recent case, a few years ago. The Court of Appeal, in a case called Rooney against Axel Middle, ultimately, the Court of Appeal confirmed what the Supreme Court of Canada held in a case called Rizzo against Rizzo, the leading case on the modern principles of statutory interpretation. And ultimately, what the courts look to and what I will look to when I'm interpreting your code of conduct to a context that is brought to me will be to look at the provision that's at issue and interpret it by considering it in its entire context, and by both looking at its ordinary and grammatical meanings in line with what they called in the old days the plain meaning rule. So you take a word respect, what does it mean? Plain and ordinary meaning. Go to a dictionary, see what it means, right? It may have several meanings, but it means something, but that's not good enough. And many people will bring a code of conduct complaint and they'll just cite, this is disrespect, this is, we'll see, discrimination, whatever section we want to look at. They'll use a dictionary meaning or a common usage or something like that, but that's not sufficient. You have to also ensure that the interpretation of that word using its grammatical and ordinary meaning is in harmony with the scheme of the statute as a whole, meaning the Municipal Act 2001, the object of the act, particularly our section, which is the part 5.1, that is the accountability and transparency part that my job is dependent on that, and your code of conduct is too, derives from there, as we said in section 223.3. So what's the object of that? I mean, clearly transparency, accountability, all these things, ethical behavior, all that's obviously part of it. And the intention of the legislature, what were they trying to get at by doing all of this? So you look at the words that are being applied to you, if they are in a complaint, what do they mean? The ordinary and grammatical meaning, but plunk them into a context. So essentially context is king, or context is paramount, and it has to be in relation to a couple things. So I can tell you that in the context that we're talking about the context of you wearing your 3 hats. Now, mostly the hat that you'll be wearing if you do get dinged with a complaint will probably be, and I can't say always, but it's probably going to be in maybe your representational or political role, right? You're going to be speaking, you're going to be writing, you're going to be out there, you're going to be saying things, whether it's in writing or in orally or by conduct, saying, doing, speaking, whatever it is, gesturing. Those are the sort of things that are going to attract attention, especially with social media and things like that. And then you're going to, step in a trap potentially with the use of your words. And then the question then becomes, what do the words mean? But what do the words mean most importantly in the context that we're talking about? And I have to emphasize the context that Mayor Davis mentioned is ultimately that's it. That the context is you're an elected official, you're a councillor, you have representational rights, you have political, obligations to represent your ward, your constituents, your so on and so forth. You have a right to disagree. You have a right to disagree vehemently. You have a right to, put up a fuss, debate, do whatever you can. But again, it has to be, if ask me where the bright line is, it has to be appropriate. It has to be in compliance with the Municipal Act, the regulations, your procedural code, your rules, policies, and procedures. It has to be consistent with that. Okay, so that's where we look to first. We look to the three things, the lenses that I'm taking you through are the context that we're talking about. The act, the reg, the procedural bylaw, and ultimately some of these decisions that integrity commissioners are promulgating now, they're writing, whatever, those are good guides, but in, the guide to, counselors, guide 2018, that's also useful, not determinative though, but all these things definitely help. So that's what we have to look at. And I know that there are integrity commissioners' decisions, and I've made some myself as well, where one would take the position, a little bit of a hands-off thing, saying it's legitimate political debate. It's words that were used in the context of a meeting or, in whatever the issue, the context was. And it's not the place of an integrity commissioner to chill, oftentimes chill free speech. You get into that sort of thing too. And is it contrary to the Charter of Rights and Freedoms to chill my speech when I'm representing a constituent or saying what I'm saying? And of course, those are the sort of things that make for litigation. As an integrity commissioner, I'm not going to write an opinion whether your code is constitutional or not. That's not for me to decide whether it's constitutional. It's duly enacted. It's been passed. I will not rule on its constitutional validity or applicability or enforceability. But I can say that there are decisions, and I'll show you one very shortly, in the context of a code that has similar provisions to what you have, and then we'll end with that. I'll let you to get questions on this part of it, and then we'll go to the new code, and we can talk about that a little bit, a fair bit more at that point in time. But what I wanted to do is look through that, I guess that fourth lens now a little bit and say, are there any other codes out there that have some similar provisions to yours? Of course there are. And I know your task, Code of Conduct Review Task Force looked at a whole bunch. I looked at over 35 codes, and I can tell you that there are similar codes out there. Yours is actually quite robust and comprehensive. And as I say, I'm a supporter of it. And I can commend those who had input into drafting and putting it through to passage. The city of Windsor, for example, has a code of conduct for members of council and local boards. And in that code, there are similar provisions. There's a couple of provisions I'll just point out to you and then say that one councillor got himself into severe hot water by a complaint lodged against him for violating these provisions. They are Rule 12 of that, which talks about conduct at council, and it reads, members shall conduct themselves with decorum at council in accordance with the provisions of the procedure bylaw. Sounds pretty familiar, right? You and 443 other municipalities probably have something similar. In the commentary, they have commentary to their code. In the commentary, little c says, Part 14 of Procedure Bylaw establishes that members shall not criticize any decision of council except for the purpose of introducing a motion for reconsideration under Section 13 of Procedure Bylaw. So that was one section of the code that is very similar to yours. Another is section or rule number 16.1. It says members shall accurately communicate decisions of council, city council, even if they disagree with the majority decision of council, and by so doing affirm the respect for the integrity in the decision-making process of council. That's another one. And then the last one is 16.2, which says a member may state that they did not support a decision or voted against a decision. However, members shall refrain from making disparaging comments about other members or about council's processes and decisions. So you got three provisions which get pretty close to yours, which we'll get to in a minute, which Windsor has had for a while. In a recent decision, fairly recent, their integrity commissioner in Windsor, Bruce Elman, wrote a decision, I believe it was dated November the 6th, 2017, and in which he dealt with a complaint about a councillor who violated these particular provisions. He investigated and he ultimately concluded that, yes, indeed, each of these three provisions were violated by the councillor's statement to the Windsor Star. We don't have to get into the details about what he said and whatnot, but he made a factual finding and concluded that those three sections were violated by words that the councillor was quoted in the Windsor Star about. What was most important, or at least was instructive to me, is sort of almost like a final, well, he calls it a final note. And in the final note, he says, some might argue that Rule 16 of the code and Section 14.1E of the bylaw violate Section 2B of the Canadian Charter Rights and Freedoms, which is the freedom of expression. He says, you know, and Elman was a law dean and the whole thing. He knows law pretty well. So he's I would say, a fairly authoritative integrity commissioner, at least by his background. And he both ultimately rejects that. And he says that that these anti-disparagement or loyalty provisions constitute such reasonable limits in the context of municipal governance. To put it somewhat differently, it is arguable that the mayor and councillors are more limited than are members of the public in what they are permitted to say, precisely because they hold elected positions of leadership and authority in our municipal governance structure. So he expands on that and he says, look, you guys as municipal councillors occupy a unique role in the society. You're both deliberative legislative bodies, right? And you are effectively a corporate board of directors for the commercial entity known as the municipal corporation, right? And in this case was the city of Windsor. You enter into contracts, employ workers, you buy and sell, so forth, all at the direction of, in accordance with the policy set by the board, but known in this case as a municipal council. In other words, in the lead up to a specific decision, council is a deliberative governmental body where an almost unfettered freedom of speech reigns. And that's what Mayor Davis was talking about. And that's what everybody talks about. It's true. It's almost unfettered in what you can say in your deliberative governmental body. But once that decision is made, and by the way, it's not unfettered, it's almost unfettered. And yes, there is also limits to free speech too, right? Like the old American United States Supreme Court, you're not, free speech doesn't allow you to yell fire in a crowded movie theater, right? There's obviously limits to free speech too. We're not going to talk about it tonight. If you want me to come back and talk about the charter, and which I have some experience in over the last 20 years in charter litigation, I'm happy to come back and talk about where the limits are to charter rights and so on and so forth. You know, whether it be, you know, equality rights under Section 15 or your freedom of speech or, you know, association, that kind of thing. Happy to talk to you where the line might be drawn there as a matter of law and jurisprudence. But just know that even these charter rights and freedoms are not unlimited and they're not absolute. Okay, but in any event, in the context of these anti-disparagement or decision-making activities, Integrity Commissioner Elman says, once a decision is made, council becomes a corporate board. And as with vast majority of corporate boards, public dissent is discouraged or even prohibited. The reason is rational and sensible. Decisions made by council become the official policy of the city of Windsor. When members of council speak out or engage in conduct indicating opposition to official city policy outside the deliberative confines of the legislative process, their commitments or conduct can diminish the integrity of council decisions in the public eye, damage public confidence in council itself, or even undermine the city's reputation domestically or internationally. One can only imagine how Councillor, well, I won't mention the name here, statement, perhaps taken as hyperbole here in Windsor, might be viewed in California or Calgary or Copenhagen or Cairo. So he goes on, I'll skip a bit here, and he says, listen, councillors can post their concerns on their web pages or go on social media to express those concerns. Councillors can go to community groups or BIAs to rally support for their position. The councillor can even encourage citizens to become delegates to council when the matter is debated. Finally, councillors may express all of their concerns during the debate on the matter when it comes before council. Even then, after the decision is made, councillors are free to explain why they voted as they did during the council deliberations. They should, however, acknowledge the legitimacy of council's decision as resulting from the deliberative and democratic processes of council. They should not be disrespectful, and their comments should not be disparaging or inaccurate. That's where the bright line is, Mayor Davis. Indeed, in the same Windsor Star article, councillors Mara and Kuzmiorensky provided reasons why they had voted against the streetcar proposal. Their statements met the appropriate standard required of councillors when explaining why they had voted against a particular proposal. Unfortunately, this councillor's comments failed to meet that standard. So that's what I have to say about bright lines. There definitely are limits. It's not unfettered rights to speak in the representational or political hat that you're wearing. And where those lines are sometimes very clear, and sometimes they're not so clear or gray. But I think the key to understand is that not only is it the interpretation of the words in their ordinary and grammatical meaning that's important, but also the context, whether it be your representational or political role, where you are when you're saying it, and also in the context of charter rights as well. You definitely have rights to speak and say and assemble and so on and so forth. But again, those rights are not absolute. They have their limits, and where those limits are basically to be decided on a case-by-case basis for the most part in the context in which we're presented. So that's where we're at there. So maybe I'll just stop talking there and see if there's any questions about that and how Integrity Commissioner Dean Ellman basically came out with that in his decision.
Yeah, I've got a different question. So it's kind of parliamentary procedure. And, parliamentary procedure, as many councils define it, and as we've defined it, it's, you're speaking through the chair or the Speaker of the House, right? And you're not to sit there and debate one another directly. Like you can't have one councillor phone another councillor say, well, that comment accounts for so-and-so. I don't agree with the accounts for so-and-so. So that obviously in a parliamentary process is discouraged, and you speak through the Speaker of the Chair. Is that a breach of charter rights, or how's that?
Yeah, I mean, you're definitely entitled to, I mean, even in the parliament, right? They do have parliamentary procedures, and they have parliamentary conventions, which go back, of course, centuries, right? So I wouldn't say a procedure bylaw by its nature, is offensive. And I would say otherwise. It gives certainty, and it gives procedural, everybody knows the rules of the game, let's sort of say. And, as long as they don't in action, in other words, in the context in which they're applied, as long as, again, there's fairness and there's natural justice, there's all kinds of things that are going on depending on the context. As long as they don't offend that in any sort of, obvious way, I would say they're perfectly acceptable and probably desirable and necessary.
Okay, Not seeing any other raised hands.
Okay. All right, two other comments then in terms of outside of Ontario. I did find that in Alberta, there's a councillor code of conduct, a guide for municipalities that they published that was, it was prepared by the Alberta Association of Municipal Districts and Counties and the Alberta Urban Municipalities Association in partnership with Brownlee LLP. I gather that's a law firm out there. In any event, I found it very useful because it's really telling the municipalities in Alberta how to basically develop a code of conduct for municipalities. And in there, on page 6 of 24, it does say explicitly, your code may confirm that once council makes a decision, individual councillors should respect the decision and should not attempt to undermine it. So and that is about as close as you can get to provisions that you've added in your code towards the end there. We'll get to it in a minute. But ultimately, there is a suggestion in this document anyway, that when municipalities are looking at developing codes, that would be something that would be useful to include in the code. So there it is. Okay, so now the other thing is, I don't want to burn up all the time. Maybe I won't say the other thing I was going to say. It's from Tasmania, which is actually a little bit off, a little far from here. But in any event, they came up with a great publication a year or two ago called the Good Governance Guide for Local Government in Tasmania. And I found it extremely helpful. I won't go to it now, but it goes to, you know, sort of what are the elements of good governance, and they've got checklists and all that sort of thing. If anybody wants it after, just let me know and I'll see if I can, I'll send you the link. So then I'll leave it at that. Those are the lenses that I wanted you to look at your new code through, set the table with principles and statutory obligations, and then ultimately have a look at the new code without going through it, you know, line by line. What I'd like to do is just highlight some of the features I thought that were excellent. I do, as I say, I'm a big fan of it. In any event, if you look at the new code, you'll see that it's actually very clear. It starts off with the authority under which it's been passed, which is the Municipal Act. To whom it applies, what compliance means, what's its purpose. It also lists in 16.1.6 the statutory provisions that operate together with and informs and acts as a supplement to the code. We've got a few more here than most of the codes are, which is actually very helpful. You've got your 4 municipal acts there. And then you got the Human Rights Code and the Occupational Health. You got the Criminal Code as well. You've also got a statement of principle, which is also very important, I think. And you've also got a section that says that if you need clarification about a part of the code, you can consult with me if you like. Now, this is different than asking me for a full-blown opinion under the Municipal Act itself. Under Section 223, as I say, one of my jobs is I can give you a written opinion, which is confidential unless you disclose part of it, in which case I can disclose the whole thing. But it's not the same thing. Asking me for clarification is not the same thing as asking me for a full-blown opinion. So in any event, you can take this up. It's something that's, I think, unique or very rare to see in most codes. And it's probably something that's, I think, a good thing to have. Okay, it's also got a fulsome definition section, which is great. It's very clear. You've got your, well, I won't go through each article. You've got the 4 prescribed subject matters in here as we go through it. You can go through it. The gifts and the use of city resources. And then I'm going to turn to now Article 8. Article 8 is where I gather there's some proscriptions here for you, and it begins, of course, with improper influence. I think that's probably a no-brainer. And then there's an interesting section here about tribunals, and interference with tribunals is prohibited. There is an exception here, which is actually very interesting, which is with regards to an LPAT, a local planning appeal tribunal. The rule says that if council has taken a position to an LPAT and the city solicitor or legal counsel is instructed or otherwise required by virtue of the office to appear at a hearing in support of that position, you are not allowed to, I've just sort of lost my place here. 1 second. No member who disagrees with the position of council shall give evidence at the hearing or otherwise work against the will or decision of the council in such matter. Okay, that also makes sense. But then there's an exception here. It says here, with the consent of the lawyer, okay, assigned to represent the city or at an LPAT hearing, a member who is in support may give evidence, okay, but then it says, notwithstanding the above, meaning, let's say no consent, and you disagreed with that decision, and it's going, right, it's going to LPAT. If the LPAT has decided to mediate a dispute between the parties in a matter, any member may offer his or her services to assist with such mediation, regardless of his or her position in the matter, and participate, if approved by the LPAT mediator. This is actually an interesting provision, actually very creative, and one could think out of the box on this one. You can participate for for the purposes of assisting with the mediation, which of course is private, confidential, and both sides are going to try to negotiate something. You could actually assist with that, but it doesn't matter what position on the issue you're taking, if the LPAT mediator says it's okay. So that's actually very interesting. And whether or not, by analogy, something like that could happen in another context remains to be seen. So I just throw that out. Now, the sections that I.C. Ellman's decision and the Windsor Code relate to are found in 16.8.3. You can just have a look at that. And ultimately, the first sentence and the last sentence are really what's important here. Members shall not actively undermine the implementation of council or local board's decisions. And then the last sentence there says, as members of council or of a local board, individual members are not to engage in activities that seek to challenge or undermine the decisions of that body. And then lastly there, members can express disagreement with council's decisions, but it is contrary to the ethical behavior of members of council to actively seek to undermine, challenge, or work against council's decisions. Now, of course, as I mentioned, these are words. They obviously have meanings. So the first word you might want to say, well, what does that mean is in the first line, actively, right? It just doesn't mean you can't undermine by doing anything. It means actively. Of course, actively, if you look up the word, it means things like deliberate, in a positive way, energetic or vigorously. It means you're really working at it. That's generally what actively means. And then the next word, of course, that needs meaning and application is undermine. What does undermine mean? Does undermine say, I think it's a bad decision? Is that enough to undermine something? Well, again, starting with the ordinary grammatical meaning of the word undermine, that normally means erode the base or foundation, lessen the effectiveness or power or ability of something, right? So again, undermine really means to, get under it and try to really erode it and, make it weaker, that kind of thing. And then, of course, the next word you would need to interpret would be implementation. What does implementation of a decision mean? Well, that's a good question. How do you implement a decision? You guys have voted, decisions taken. There may be dissents or disagreements on, whether or not, they vote for or against a matter. And, but a decision is taken and goes by the majority. What happens next? Well, the decision has to be implemented, which means a process of putting the decision into effect, executing on the decision. So if you put all that together, this sentence can be read much more narrowly or much more precisely with certainty if you give it the meaning that ordinary and grammatical meaning, has for it. So that would be number the way you would do it. But again, you would need more than that to say whether or not that's grounds for a complaint under the code, because you need a context, and I need to know more, for example, to even, sort of rule on that, as we talked about before. Okay, the other section is 16.8.4, encouraging litigation. It says in the first sentence there, members shall refrain from encouraging others to bring legal challenges against the city, local boards, other members and staff regarding action or decision of the city, et cetera, right? So again, you get into what does encouraging mean, right? That would typically mean giving somebody support or confidence, giving hope for future success, that kind of thing. And it really is, you're on the positive side and you're, essentially saying, look, bring a lawsuit, bring a JR, judicial review, bring a legal challenge against whatever, whatever's captured here. So that's what it would mean there. And that then, if we flip the page or carry on to Article 10, that kind of jives with the same kind of conduct that's captured here as well, since we're sort of on this narrow part of it. Article 16.10.1, little d, says at all times, including in the course of their official duties, and again, official duties is defined at the beginning, members shall not impugn or malign a debate or decision or otherwise erode, I guess that would be the same flavor as in the other section, the authority of council or the local board. And then in G, again, it says, abide by all applicable legislation, policies, procedures pertaining to his or her position as a member, et cetera, et cetera. Then there's some exceptions in there in 16.10.2. You'll see there that in the third paragraph, nothing in this article shall prohibit members from discussing or communicating among themselves, provided that, and here is some of the barriers or the boundaries within which you ought to keep yourself in, as long as you act lawfully. Again, the Municipal Act, related legislation, the regulations, the code, appropriately and in a manner consistent with the act, the code, applicable bylaws, policies, procedures, rules, and other relevant legislation, right? So those are your boundary lines. And then a couple paragraphs down, it says a member may state that he, she did not support a decision or voted against a decision. However, in doing so, a member shall refrain from making disparaging comments about other members, staff, or the processes and decisions of council or the local board. So that pretty much rounds off what we'll call the anti-disparagement clauses, or the clauses where you're not to take a position that undermines or erodes the decisions of council. And we've talked about sort of the underlying principles in relation to what roles you all play, the three hats, and so on and so forth, and the statutory duties. And in that context, this is where your new code and these provisions find themselves. So ultimately, that's sort of the features that I'd like to talk about. I mean, you obviously have other terrific features in here relating to social media and respectful workplace and staff and nepotism and all those sort of things. and also a section about training. And from time to time, I've been given the authority to recommend training to members with respect to this code and other applicable legislation and so on and so forth, and can make a recommendation in a report that I do following an inquiry that that training be part of that, as opposed to potentially other punitive things that might otherwise find themselves in other codes here and elsewhere and so on and so forth. So again, it's novel, it's thinking out of the box, and I think it's actually a very good thing, and it gives I think an appropriate course of action for remedial actions to be recommended, and it's up to you to decide whether or not you implement that if it does find itself in one of my reports. So with that, I think I'll stop talking, and I'm happy to answer any questions you might have about any of it.
Well, Mr. Huberman, we do have a question from Councillor Wall.
Great, thank you. Could the clerk bring up 16.8.3 quickly? Right, at your own pace. I mean, bring it up for me quickly. So 16.8.3, the very last line there, members can express disagreement with council's decisions, but it's contrary to the ethical behavior of members of council to actively seek to undermine, challenge, or work against council's decision. So I had numerous constituents and members of the public post on social media and comment and call and ask what ethics has to do with it. And then I'm just curious if you could elaborate a little bit further on that particular word.
On the ethical behavior of members?
Yeah.
Well,
so they were like, ethics, somebody's ethics could be contrary to another person's ethics. And I just Googled the definition of ethics just
right.
for fun. And really quickly, moral principles that govern a person's behavior or the conducting of an activity.
Right.
So
Yeah.
I'm just curious. Thank you.
Yeah, no, well, let's pull up 16.1.5 and you'll see the link to ethical behavior there.
So ethics is defined in our own code.
Yeah, but also the purpose of the code encapsulates ethical behavior too. Of course, a code of conduct is, of course, governs your behavior. So let's look at it together. Code of conduct helps to ensure members of council share a common basis understanding what's acceptable conduct. Okay, so we're talking about acceptable conduct in the discharge of their official duties. A code of conduct also promotes public confidence that members will operate from a foundation of integrity, transparency, justice, truth, courtesy, and accountability. Of course, those are all ethical characteristics, right, or traits. So just to name a few, but ultimately, you know, and of course, me as the integrity commissioner, integrity is of course at the core of ethical behavior. And that's what section 223 actually specifically gives me the jurisdiction to deal with the application. If you can look at 223 again, let me just see, I've got that here. Yeah, the 223.3 sub 1 of the Municipal Act talks about the functions assigned or performed by an integrity commissioner involve the application of the code of conduct for members of council and the code of conduct for members of local boards. And number 2, the application of any procedures, rules, policies of municipality and local boards governing the ethical behavior of members of council and of local boards. So of course, ethical conduct is at the root or the core of your code of conduct and the expectation that members of council will adhere to high standards of ethical conduct as set out in the code and in the relevant legislation, bylaws, rules, procedures of the municipality.
Okay, so our ethics and the ethical behavior of a member of council for the corporation of the city of Brantford is laid out in the code of conduct.
I wouldn't say it's necessarily exclusive to that, because the code incorporates other related and legislation and other things as well. But certainly that's the primary source for it, including, its root, which is the Municipal Act 2001 and other legislation, right? So one could even say, for example, the Municipal Conflict of Interest Act, which ultimately says in it specifically that the province of Ontario promotes and expects that councillors will adhere to the principles of integrity and so on and so forth in performing their roles as councillors. So you've even got a statutory provision right out that talks about integrity, right? So, and integrity, of course, is a really an elastic term that encompasses a whole host of bundled up character traits and behavior, activities and so on and so forth. So, that is the standard and the expectation and the requirement for councillors to adhere to is integrity and honesty and all the rest of it, plus all the other things in the code.
Awesome. Thank you very much for that answer.
Yes, I don't see. Yes, sorry. Not anyone else. Don't see anybody else raising their hand on that section. Now, is there a fifth section now, Mr. Huberman, that you want to review? Or
Let me just have a look here.
not that I'm suggesting, I just trying to remember how you prefaced your presentation. So
yeah, I think the fifth section was ultimately looking at it from a critical or a discerning eye, with a view to what might be sort of pockets of or provisions that might attract some attention, or might be sort of hot areas. So
these would be potential pitfalls for us.
Yeah, so obviously the ones that I highlighted in my preparation, I understood, and that there may be, as Councillor Wall has indicated, that people have commented about what's this all about, ethics and so on and so forth. There may well be people who will say raise that whole issue about undermining decisions of council. I think that's a very important area to be very mindful of as well. Is obviously you got to know where to draw the line, and I think what this code does is it takes a proactive approach and puts it out there. You didn't have to say it. It's probably implicit, but I think I find in my experience it's better not to be so implicit and be explicit. It's better that you guys should know what you're up against, and the public should know what the expectations are and how these things are handled. So so those sections I think I've covered fairly comprehensively. We've talked about it, why they're there, what other jurisdictions have done with it. We have an Integrity Commissioner decision on interpreting it to mean that there are boundaries. Rights are not absolute. They definitely have boundaries to all of them, even under the charter. My big key here is that, again, it's contextual. So, it's easy to say it's contextual, but you do have rights, to a fair bit of leeway on where you guys can go. And I'm the first to say that you do. You are special in the roles that you play, especially your representational role, your political role, your advocacy role, all that stuff like that. You just have to be very careful about when you are in that role, that you are mindful to stay on side. And So sessions like this are hopefully helpful for you to understand where maybe the boundaries are. If you're not so clear, you can certainly call me for clarifications or whatever you want to do. You want to get more formal, you can ask for an opinion, I'll give it to you. You know, that's where we go there. But I do want to say also, so here's another thing. There are going to be people out there that are going to say, well, you know, maybe they won't be so mindful and they'll step in the trap, and they'll get a complaint against them, or they'll say, so what's the downside of doing this? Let me say this. In your capacity as an official, as a counselor, or as an officer, or as a staff, or as an employee of the city corporation, city of Brantford, you have statutory immunity. I believe it's section 448 of the Municipal Act. And what that does is it protects you for the most part from legal actions if you're acting in that capacity and if you act in good faith. So if you're, the key words are, again, it's interpretive, right? Good faith in the performance of your duties as a counselor, as an officer, as an employee, or as an agent, this is what the section says, then basically you're immune from civil liability. That's it. That's what it says. It doesn't mean that, and then the other section below that talks about, well, the municipality can be sued still for the tort that maybe one of you engage in or whatever, a civil action that has some consequence in law. Fine, that's a tort, you know. But again, we're gonna have to look at it in the context and so on and so forth. But that's the good news. The good news is if you're acting in good faith in the performance of your duties, you generally have statutory immunity. That's the general rule, and that's the statutory, and you know, and as long as those terms are met, you're probably pretty safe. If you're acting in that capacity, but you're not acting in good faith, you wouldn't have statutory immunity from civil actions. That's the bad news. So question is what's good faith? Again, it has been interpreted in case law and so on. So it generally means you're honest, you're candid, you acted, with, reasonable, that kind of thing, as opposed to knowingly acting beyond the scope or whatever it is. So let's take one of these examples. Let's say you go around, you say nay to a decision of council, and you go around on social media doing exactly what these sections of the code says you're not allowed to do. You actively undermine, you challenge it, you go crazy, you're telling people what to do. Go, bring a class action, you guys, against the councillors or against the municipality. Let's just be, as extreme as we can on this. Let's say you go wild on this, okay, and you get a complaint against you, and let's say you kind of know that that's really gone beyond the pale here. You crossed the line. You've definitely actively undermined. You've challenged it. You're not just, giving, telling people, well, you know what, constituency, you don't like that. We voted this on a development or whatever it is, whatever the issue is. You go way beyond that, and you actually actively encourage litigation. You do, we could almost do like a law school exam here, give you the fact pattern, and it would be so obvious that you offended these sections. Assume you did. If you acted that way, you probably are not acting in good faith. So you're subjecting yourself right away to liability through civil action, whether it be, for example, maybe you could get sued for maybe defamation. And maybe that bad faith would also be malice, which would also undermine your qualified privilege defense, which you guys have, right? In a different way than the general Jane public, whatever. But generally, if you say something defamatory and someone gets their nose out of joint and it actually constitutes the tort of defamation, you may have qualified privilege unless you're acting maliciously. Now, bad faith might be indicative of malice too. So going rogue on this kind of thing is at your peril, because A, you might offend the code, in which case I may find that you've offended the code or contravened the code, and recommend a penalty or training or both or whatever. That's number one consequence. But you also might be sued by the people who, you know, don't like what you had to say, and you may lose your statutory civil liability immunity, because maybe that's, I'm not saying it is, but it might well constitute bad faith, or at least not good faith, in the performance of duties. And more than that, it seems to me that putting aside the bad faith, which might subject you to tort liability, which might be defamation, maybe it's abuse of power, maybe it's misfeasance in public office. I'm not saying it is, it may well be. It's tough to prove those things, but bad faith and maliciousness and so on and so forth might well found at least one or more of the elements, and might subject yourself to that kind of potential liability. That's number one. But number two is you're probably not acting in your capacity as a counselor anymore, because as I tried to show before, in the decision-making process, when you're wearing that hat as a decision maker, once the decision is made, that process is over, other than implementing the decision. But if you're ultimately undermining the implementation of that decision, in what capacity are you acting? You're not acting as a decision maker anymore, because the decision's been taken. So you're not acting in the other stewardship role. You're not acting in, you know, in the other role either. So what role are you acting? You may well be acting in your individual personal capacity. It's pretty hard to take off all your hats, you know, as a municipal councillor, and then say, you know, I'm now stripped of, you know, my immunity, and I'm not acting in any official capacity. I'm acting my own. Well, you know what? If you're acting on your own, you're on your own, and therefore you wouldn't have the defenses available to you as municipal councillor, or, you know, under the statute, or maybe even for tortious liability, that kind of thing. You really are, you know, going on your own path, and exposing yourself and potentially others as well to civil liability, or maybe even worse. So that's all I'm saying is that, you know, just be very careful about what you do, you know, under your new code. For the most part, I think it's very clear. It's very concise. The words, I'm sure, will need some interpretation as we go along, but they'll be given the right interpretation and in the right context. And, you know, it will be given, you know, it's the proper, you know, treatment that, you know, it necessitates. And that's pretty much sort of the advice that I want to leave you guys with, is that's where you guys have to be. You have to be aware of what it is and stay within the boundaries. And when in doubt, ask questions, or, you know, don't do what you think you might offend the code, right? You know, refrain from doing it, or get some advice on that from me, or from your own lawyer, or legal counsel, right? So that's basically the advice. And then of course there's other sections in the code we can talk about anytime you want to as well, the social media stuff, whatever it is. Those are also very clear, and I think say what they're meant to say. So that's what I
have a couple of questions for you. So the code of conduct that you and I operate under, because I'm still a member of the Law Society of Ontario, is there's often commentary. You'll see a rule, and then there'll be examples, usually taken from decisions that have been made, right?
Right.
And it builds over time with various decisions and incidents and complaints. Is that something you'd recommend that we do with our code of conduct? So it doesn't actually form part of the rule, but it's often there, at least with the lawyer's professional code of conduct, so people can better understand what that rule means.
Yeah, I think it's an excellent idea to have. You know, as you know, I've consulted the rules of professional conduct for Law Society of Upper Canada, and now Law Society of Ontario, as it's now known, for, you know, for as long as I've been a lawyer. And the commentary is extremely helpful. And it also helps if lawyers ever do get into trouble, they can rely on the commentary and say, well, what do you mean? You know, this is how you guys interpret it. You know, what do you want from me? So I do, and for the public as well. I think it's a terrific way, because otherwise, you know, what you have is just a bare bones code, like, you know, all legal codes can't just be left by themselves, right? There's body of law that goes with it to interpret it, and it develops over time. So if we can fast track it and have, you know, or over time build on a commentary section for the code, and you know, and maybe even include how other integrity commissioners are, you know, interpreting it or whatever, that would be fine. Although, you know, one integrity commissioner isn't bound by what the other integrity commissioners say either. You know, it's not like the, you know, stare decisis or the rule of precedence as they are in the court. So you know, it depends, you know, what, you know, some you may not want to put in some decisions of some integrity commissioners on an analogous rule or not. But yes, as a general principle, I think a commentary, annotations, that kind of thing is a great idea.
Okay. I see that we have two questions come up. Councillor Utley and then Councillor Wall again.
Thank you, Mr. Mayor. I wanted to make a comment, if I may, or do you want me to save that for the end?
No, this is, you know, I said I've relaxed the normal rules and comments, questions.
Okay. First, I'd like to thank Mr. Huberman for this training. It was a very valuable experience, and it was done in layman's terms that guys like me can understand. And I'd also be remiss if I didn't thank Councillor Wall and the committee, Code of Conduct Committee, Heidi DeVry, who played a key role in putting the Code of Conduct together, and also Tanya and the clerk and her staff. So, and thank you, Mr. Chair, for chairing tonight. Did a fine job.
Thank you. Councillor Wall.
So my question was going to be to you about whether we could do commentary, but Councillor Utley's asked that. But first, a question for our Integrity Commissioner. I don't know if you can answer this, but I'm going to ask it anyway. You have experience with other codes of conduct. Do you believe that there's anything that not necessarily we're missing, but anything we should consider or be looking at incorporating into this code in the near future?
No, I don't think it's missing anything. And again, if a situation comes up that somehow raises an issue about what's this or what that, then sure, it's situational, it's case by case or whatever. But the code that you have now as your new code is comprehensive, it's clear, it's concise, it's coherent, it covers as more than, you know, which it would be adequate. So to me, this is something you should all be proud of. And as I say, I commend those who were involved in the task force task force, and particularly Heidi, who took a lead role in drafting and putting pen to paper and so on and so forth. And I was consulted in part at a very high level as you were doing what you were doing, and I definitely give it my blessing.
Next question. If I'm not mistaken, were you not instrumental in the creation of this code of conduct?
Who's
you?
Was I instrumental? I wouldn't say I was instrumental. I was consulted. I would give the glory to the task force and to Heidi, who really did the job. But I was involved in some calls and some review of some things.
So then in my commentary then, yes, we are incredibly thankful to our staff who were thanked profusely during the task force as well as during council during this. But thank you. Thank you for being our Integrity Commissioner, for being there when we call. I know that you've taken a few calls from me, and I'm sure from my colleagues as well. Thank you for this training, and thank you for helping us create a code of conduct that we could be proud of and that could be emulated perhaps by other municipalities who need to update their codes of conduct. So seriously, thank you for everything and for being here today.
Thank you very much. My pleasure.
Councillor Utley?
Thank you, Mr. Mayor. I do have a question through you to Mr. Huberman. is there, in your opinion, is there anything in this code of conduct that you feel uncomfortable with or should be taken out?
Not at all.
Thank you.
All right.
Thank you very much.
Councillor Carpenter.
Thank you, and thank you for your explanation. The new Integrity Act allows the public to file complaints. In the past, it didn't, and there was a fee. Have you seen an increase in public complaints under the Integrity Act with these changes?
Well, it's, I don't really follow the stats in terms of increase in complaints and whatnot. There are a number of complaints. Over the last couple of years, there have been an increase in complaints, but I think that's also partly because there's public awareness about the fact that the Municipal Act now has made it a requirement to have codes of conduct across all of the 444 municipalities, and it's been advertised and marketed, and I think rightfully so. The public should be informed of all of that. So I think that because more people are aware of it, more people are now availing themselves of it. But I also say a lot of the disputes also resolve informally too. So there's a plus there as well. So yeah, I just think it's a good thing for everybody to have, what the provincial parliament put forward in the form of, this dispute resolution procedure, which allows for, complaints under codes of conduct to be made to an integrity commissioner, and also for a municipal integrity commission and municipal conflict of interest matters as well. So I think, it really did take things away from the courts, which of course have their own problems and with delay and cost and so on and so forth, and uncertainty with COVID. And it allowed for people to express their concerns or their, what they have on their minds in a way which allows for this kind of procedure to be followed.
So having said that, do you think that we should make the public more aware of what their rights are under this code of conduct as well as part of our educational process?
I do. I think that it would be desirable and necessary for municipalities, including your own, to educate its constituents about the new code of conduct and what it involves and so on and so forth. And yeah, I think education and training for them would be a good thing too.
Thank you.
Well, Mr. Huberman, I don't see any other hands raised. I think you've completed your presentation. You hit the 5 different areas and sections that you wanted to. I want to thank you. You've given us a very thorough overview, and very much want to thank you as well, working with our city solicitor in fine-tuning our code of conduct to, as you say, make it something that we can be proud of. I'd also say this, that it is a new code of conduct. So I think we're going to go through a little bit of a learning period. There, almost certainly it'll generate complaints. And that, I think that's probably a good thing in the sense that it'll give us some decisions and some direction from you as to, what some of these sections actually mean and how they'll be applied. And so I don't think that we should take complaints being made as somehow that's a terrible thing, but probably given a new code of conduct is a useful thing as this council and future councils, fully flesh out and deal with and understand this code of conduct.
Okay, thank you.
Yeah. So, not seeing any other questions, I'll call this, get this meeting is now adjourned, and we'll be reconvening tomorrow. And once again, thank you very much, Mr. Huberman. I'm glad that we were able to bring you down virtually this time and didn't have to have you take the trip to Brantford.
Thank you. All right. Nice to see and speak with all of you.
All right. Thank you.
Good night, everyone. Good night, everyone.
Good night, everyone.